All right, I have 12 o'clock here, so we will go ahead and get started. Our presentation today is on wrongful convictions, and I will go ahead and turn this over to our presenter, James Mayer, who is a managing attorney at the Great North Innocence Project.
Okay, great. Thank you, Sarah. Thanks, everybody, for joining me. Always happy to talk about the problem of wrongful convictions and some potential solutions to it. And I appreciate all of your interest in the topic. I'm going to try to share my screen. Let's see how that goes. Have I done that correctly, Sarah? Am I good?
I'm seeing a PowerPoint here. If you've got it in slide
Good.
share mode.
There we go.
Yep, there you go.
Okay. Great. Well, as Sarah mentioned, I'm a managing attorney with the Great North Innocence Project. I've been with the project since 2019. Great North Innocence Project is based here in Minneapolis, Minnesota, but what we do is work to prevent wrongful convictions from happening and to remedy wrongful convictions in Minnesota, North Dakota, and South Dakota primarily. We also do some work in other states as well, but our primary territory is Minnesota and the Dakotas. And as we think about kind of the genesis of the Innocence movement and the beginnings of the Innocence Project, started in New York in the 1980s, it all started with DNA technology. DNA was very, very important to the beginning of the Innocence Project. But I do say that DNA is only the beginning for the reasons that follow. Well, it started as DNA because this was a new technology that came about in the 1980s that finally allowed us to, with scientific certainty, connect crime scene evidence with a specific individual or source. Before that, we were kind of flying blind in terms of investigating crimes where biological material was left. We had blood types, we had things of that nature, but we didn't have anything as powerful as DNA technology. And that's sort of how the Innocence Project got started, with the goal of using this new technology to uncover wrongful convictions and to free the innocent. So, the onset of DNA technology was bad news for people who had committed crimes and left biological material at the crime scene, but it was very good news potentially for people who had been falsely accused and falsely convicted. And so this was important for two reasons, really. It was important because it was a way to free people who had been wrongfully convicted. How many people are wrongfully convicted? Well, we're learning more and more about that. Most of the studies put that at somewhere between 2 and 6% of all convictions being convictions of innocent people, which may not seem like all that much, but when you think about the fact that at a given moment, we have more than 2 million people behind bars in the United States, we begin to talk about a lot of unnecessary human suffering. And of course, it isn't only the people who are wrongfully convicted themselves, but we're also talking about the ripple effects of those false convictions in terms of those people's family members, those people's communities, and the loss of trust in the system that comes from false convictions. The other reason this technology in terms of the innocence movement was important was that it gave us data. It gave us a data set to work with. As we started to uncover false convictions using DNA technology, it allowed us to have a data set that we could examine and take a look at to know not only the potential prevalence of wrongful convictions, but also taking each one of those things and doing sort of a post-mortem examination of the conviction to try to figure out where the system went wrong. What are some of the factors that we see come up over and over again in cases of wrongful convictions? And so this chart provides some of that information. This is from the National Registry of Exonerations, which is a website maintained by the University of Michigan. If you're curious about the topic, I would highly recommend taking a look. This slide is a little bit out of date. We've now got well over 3,000 documented exonerations that are listed on that website. It's searchable. It's very interesting to just kind of browse. Anyway, this is a chart showing the wrongful convictions separated by various contributing factors. And these are some of the ones that we're most concerned about that we see most often. As you see on the left side, we've got mistaken eyewitness identification being a big one, almost a third. Obviously, perjury, false accusations, a big problem, 60%. False confessions, which may surprise some people, more than 10% of the documented exonerations involved some kind of confession by the perpetrator to a serious crime that he or she didn't commit. We've got bad forensics, which we'll talk about. And then in more than half of those false convictions, we've got some kind of official misconduct, be it law enforcement, police, prosecution, either one of those things. This is a slightly different way of looking at the same information, broken down by the type of crime. A couple of things that stand out as interesting to me in this chart is that if you look at the most serious crimes like homicides, for example, you see that purple line for official misconduct going up. Also the false confessions, the yellow line going up to over 20%. I think that's a reflection of the very real pressure that is felt by law enforcement and by prosecutors to convict someone where there's a very serious, notorious crime in the community, sometimes leads to, could be coercive interrogations, maybe improperly coercive interrogations. Causing a false confession could lead to suppression of exculpatory information by the prosecution, where there's a great deal of pressure to get a conviction. Another thing I notice about this is that in the case of sexual assaults, you see the blue line, that's mistaken eyewitness identification, more than double what it is just for the general exonerations. And that's because it's something that we saw in this first wave of exonerations in the late 80s and in the 90s. A lot of those were stranger rape cases where the only real evidence we had against the perpetrator was an identification from the victim, often made under very difficult, viewing circumstances, a stressful situation. So that was really eye-opening to see, where a lot of those cases where the victim had said, "That's the person, I know that's him, I could never forget that face." DNA later showed that they, in fact, had made a false identification, through no fault of their own, but they just thought they recognized the person, and we know now that they didn't. So breaking down some of those individual categories, I'm going to go a little bit quickly through some of these slides because I want to be able to tell you about a couple of recent cases, and I want to devote more time to those stories and how they illustrate some of the things I'm talking about. But perjured testimony, obviously a big contributor to wrongful convictions. More than 60% of false convictions had some kind of false testimony. One of the most pernicious types, and the types that we're most concerned about in cases of serious crimes, we're talking about jailhouse snitch testimony. These stories you've heard about, where someone is accused of a crime, they're in a holding cell, and then one of the people they're sharing the cell with later comes forward and says, even though I just met this person, he decided to unburden himself to me and confess his role in the crime, and include some details that only the actual perpetrator would know. We then see those people testifying at trial. It's not reliable testimony because it's incentivized testimony. I think prosecutors don't like to rely on jailhouse informant testimony. In my experience, the weaker the case is against the defendant in terms of the physical evidence and other evidence, the more likely the state is to rely on jailhouse informant testimony. They don't want to use it, but if they need to, they will. But it's definitely problematic. Certainly the defense can't go around offering things to witnesses who are willing to testify for the defense. So there's really, there's a lack of equality between the prosecution and the defense on this issue. So what are some of the solutions to the problem of jailhouse informant testimony? Two things that I think would be important. One is transparency. If someone is seeking a deal, if they're being offered a deal in connection with the testimony they're providing, whatever benefit they're hoping to get or that they will get should be disclosed to the defense. That's important information for the jury to hear in terms of whether the witness has some incentive or bias in their testimony. And other things that have been talked about include jury instructions. To let the jury know that there are problems with this testimony, that they should consider the fact. It's important that they consider the fact that this is incentivized testimony in evaluating its credibility. We did work for reform in this area, and there is a law in Minnesota that's just been in existence for a year or two now. That's Minnesota Statute Section 634.045. And it's really going after this transparency issue. Right now, we're tracking jailhouse witness testimony. to provide prosecutors better information before they put a potential witness on the stand. Oftentimes we see the same person testifying over and over and over again because they've learned how to game the system. They're repeat offenders. They spend a lot of time in prisons and jails, and they learn how to use that and leverage jailhouse informant testimony to get what they want. If we track it, then we can find these serial testifiers and take that into account as we evaluate whether we'll put them on the stand and believe what they have to say. Requires disclosure of the testimony and deals struck for these witnesses. Again, transparency being very important, and also providing notification to the victims. Remember, the jailhouse witnesses are people who have victimized others. And if they're getting deals, if they're getting time off their sentences, if they're getting reduced charges because of their testimony, that's something that should also be disclosed to the victims of their crimes. And so that's all in Minnesota law now, hopefully making some difference to the problem of jailhouse informant testimony. I mentioned eyewitness misidentification, single greatest cause of wrongful convictions overturned through DNA testing. And again, a lot of those are those early stranger rape convictions where the only evidence was an eyewitness identification by the victim of a stranger. Very, very difficult to do. And of course, it's important to remember that there are two sides of this issue. Not only are we concerned about the person who is falsely convicted of committing a crime, we've also got the fact that the actual perpetrator of the crime then gets away with it. So in about 30% of these cases, the real perpetrator was later identified, again, through DNA evidence. And in those, the real perpetrators had committed over 100 new violent crimes that included additional rapes and murders. So again, these issues are important to work through in order not only to free those who've been falsely convicted, but to catch the actual perpetrators and protect the public. We know a lot more about eyewitness identifications now than we did in the 80s, partly because through these DNA exonerations, we've been able to look at what's gone on in those bad identifications and figure out what the problems were. There's also been a wealth of social science research in the last few decades that tell us a lot more about what makes for a good or a bad identification. You may have heard about the notorious unreliability of cross-racial identifications. The social science has shown that people are very, very poor when it comes to accurately identifying someone of a different racial group. Same thing with cross-age identifications. Young people have a difficult time identifying older people and vice versa. We've got the weapon focus effect, something that has been a real factor in a lot of those stranger rape cases. As a matter of evolutionary psychology, it's not difficult to understand why someone who's in a very, very stressful situation, their life is at risk, there's a knife or a gun being pointed at them, they have the fight or flight response, and all of their attention will be focused on the immediate threat to their life, which is the weapon, not so much toward analyzing the facial features of the perpetrator, the shape of their nose, the color of their eyes, that sort of thing. We also know it makes for good identification. And again, there has been some legal reform on this issue that's now been standardized in Minnesota law. There's a uniform standard that is to be adhered to by all law enforcement jurisdictions in Minnesota. That's in section 626.8433. We call these four things the core four. The first being the person administering any live or photographic lineup should be unaware of the suspect's identity. We should have cops who are not involved in investigating the case administering the lineup. That's the only way that we can ensure that there aren't clues given to the witness, whether they're inadvertent clues or deliberate clues. If the officer administering the lineup doesn't know who the suspect is, that's the way we can be certain that won't happen. Number two, before the procedure, there must be an instruction to the witness that the perpetrator may not be in the lineup. It's really also important to tell the witness that even if they don't pick someone, the investigation will continue. What we want to avoid is suggesting to the witness that they have to pick someone. If we tell the witness that they have to pick someone, the big risk there is that they will simply choose the person who looks most like the person who committed the crime, which of course is not a valid identification at all, and it's a recipe for a false conviction. Third part of the core four is that the non-suspect fillers used in the lineup, they should look similar to the eyewitness's description of the perpetrator. think that one kind of fairly obvious, speaks for itself, and I'll show you an example of that in a couple of slides that illustrates why that's important. And then finally, right after the identification is made, it's important to document the level of certainty that the witness expresses. And the reason for that is oftentimes we will see a witness identifying someone out of a lineup, maybe 50 or 60% certainty. That kind of looks like the person. I'm not sure, but yeah, it looks sort of like them, similar features, similar nose, something like that. But then by the time we get to the trial, where the witness maybe has seen that image multiple times, the witness isn't remembering the original event. The witness is remembering the photographs that he or she looked at in the identification process, such that by the time the witness makes the in-court identification in front of the jury, we get this dramatic moment where he or she says, that's the person, that's the one, I could never forget that face, I'm 100% certain. If we document the confidence level at the time the identification is made, then we can avoid that problem. This is just to give you an illustration of the issue of fillers and to suggest that, while we've made a lot of progress on these issues, there's still a ways to go. This is not all that long ago, a six-pack, as they call it, a photo array that was used to identify a perpetrator. The description given by the witness was that the crime was committed by a young Hispanic male. If you look at the composition of these six photos, you can see why that would be a problem, right? At worst, a 50-50 shot at identifying the suspect, really not good enough to convict someone beyond a reasonable doubt. We've got the issue of official misconduct. As I mentioned, that could be police or prosecution. I put Jack Smith on the slide, not because I have any evidence he's committed misconduct, but I used to have a slide about ineffective assistance of counsel, and I had Rudy Giuliani on it, and someone told me that was too partisan. So I figured I'd put Jack Smith on here and kind of even things out a little bit. If it's police misconduct, we're talking about coercive interrogations, sometimes outright fabrication of evidence. The prosecution, most commonly what we see is suppression of exculpatory evidence, violation of what you probably know as the Brady Rule. Sometimes it could involve the presentation of false testimony, whether from fact witnesses or even from expert witnesses. Somebody asked a question whether confidence correlates with accuracy. I would say very, very loosely, not as much as you might think in terms of eyewitness identifications. Let me move on from official misconduct. False confessions, I mentioned to you, more than 10% of documented exonerations involved a confession by the wrongfully convicted defendant. A lot of factors go into that. The biggest recipe for a false confessions would involve some attributes of the person being interrogated, some kind of potential vulnerability, whether it's because of age. Most false confessions are from people, whether it's juveniles or people in their lower 20s. Some kind of potential mental illness, chemical dependency. Those things make someone much more susceptible to a false confession. Other things relating to the circumstances of the interrogations and the techniques used. If it's a long interrogation, 4 hours, 6 hours, 12 hours, at some point with the pressures brought to bear, the witness will say anything to get out of that interrogation room, particularly where the police will make false representations to the person. Something like, we've got your DNA, we know that you did it, it's going to be proven, combined with a promise of leniency. If you confess now, it's going to go much easier on you, you'll get a lesser sentence. So a combination of deception and a promise of leniency is often a recipe for a false confession, particularly for someone who's in a vulnerable population. One of the potential policy solutions to this is to ensure that all custodial interrogations are video recorded. That's been in the rule in Minnesota for several decades now. It's becoming more widespread in the US. The yellow states here, this is a little bit out of date. There's some more states who record interrogations as a matter of law now, but still a long way to go in terms of making that a nationwide practice. Bad forensic science, as I mentioned earlier, over 50% of the first 225 wrongful convictions overturned with DNA evidence involve some kind of improper or unreliable forensic science. Of course, Forensic science testimony can be very powerful to juries, and so it is definitely subject to abuse. Interestingly, in 2009, the National Academy of Sciences put out a report. They were asked to do a comprehensive systemic evaluation of the types of forensic evidence that was being used around the country in state courts to convict people of crimes. They took a very comprehensive look, and their findings were very stark. What they came out with was this striking conclusion that, with the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. So according to the National Academy of Sciences in 2009, we've got science, nuclear DNA technology, as we've talked about, and we've got things that really can't be called science. Things like hair analysis, bite marks, ballistics, shoe prints, a lot of these pattern analyses. And a lot of that is because these things are useful law enforcement tools. They can help eliminate suspects. They can help law enforcement go in a certain direction, but they don't have the kind of rigor that would make it reasonable to convict someone beyond a reasonable doubt based solely on this type of evidence. Just they don't have enough science backing them. Progress has been made in a lot of these areas over the last 10, 20 years, but still something to be viewed with extreme caution. And just a quick story about how science can go wrong. This isn't one of the main two cases I'm going to be talking about, but I do want to mention Michael Hansen, a client of ours who spent 6 years in prison. He was convicted of murdering his infant daughter. And what happened was that he woke up one morning, he was sharing a bed with his daughter, and she was unresponsive. He called 911, she was taken to the hospital, and she was shortly after that pronounced dead. As they examined and did the autopsy and tried to figure out the cause of her death, one of the things that was uncovered was that she had a skull fracture. And the medical examiner who did the autopsy looked at that skull fracture and determined that the cause of death must have been some kind of beating at the hands of her father, Mike Hansen. There was no other explanation for it. And that was the cause of death. On the strength of that, he was convicted of murder. We investigated that case. We got a number of medical experts to review the evidence. And what they found was important. They found that the skull fracture that she had presented with at the hospital that day was a healing skull fracture. It was in the process of healing, which showed that it was several days, maybe more than a week old. The other thing they found was that there was no underlying brain damage. Skull fractures don't cause death. What would cause death would be damage to the brain caused by the same blow that caused the skull fracture. In this case, brain damage was not the cause of death. The skull fracture had happened earlier and it had nothing to do with the death. Further investigation showed that more than a week before this incident, while the baby was with her mother at a Walmart, she was in a shopping cart in her car seat and had fallen off the shopping cart in the parking lot. She'd hit her head. It was a significant enough event that Walmart still had documentation of the incident that happened. But the baby was okay. Babies can be pretty resilient. That skull fracture was healing, but that was definitely not the cause of death. The cause of death was, what's often called sudden unexplained infant death syndrome, sometimes referred to as positional asphyxiation, could have been the way that she was sleeping. But in any event, it wasn't the beating at the hands of Mike Hansen. On the strength of that new medical evidence, Michael Hansen was then released after spending 6 years in prison. One thing that was not on the chart earlier, but which sort of underlies a lot of wrongful convictions, is ineffective assistance of counsel. As you all know, a criminal defendant has a right not only to counsel, but to the effective representation of defense counsel under the Sixth Amendment of the U.S. Constitution. The way our adversary system works, everyone's got a role to play. The judge has a role, the prosecutor has a role, the jury has a role, and defense counsel, of course, has a very important role. If any player in that system doesn't do his or her job, we're going to have a problem. Oftentimes, that person is defense counsel. Have to mention racial bias when I mention wrongful convictions, because even if you account for the overrepresentation of people of color in the criminal justice system. It's nevertheless true that people of color are more likely to be impacted by wrongful convictions than others. One of the things that we're up against in the work that we do, which is post-conviction work, right? We only get involved in a case after there has been charges, a trial, a conviction, direct appeals have been exhausted. Only then do we as an organization get involved trying to set aside false convictions. The fact is we're up against a policy of finality. Minnesota laws nationwide, policies favor the finality of convictions. And there's good reason for that. I have some sympathy for the notion that for the victims of crimes, for the families of victims of crimes, and for prosecutors, the idea that after someone's been convicted of a terrible crime, we could have endless and repeated litigation over it, even where it's obvious the person is guilty. I have some sympathy for that idea that we would want to have laws and policies that, favor finality of convictions. All the same, what we are learning, and in our work, what we're up against is the fact that sometimes that finality, oftentimes that concept of finality, is at the expense of correction of real errors and at the expense of justice. We've got statute of limitations. Minnesota post-conviction statute has a very, very strict 2-year statute of limitations for claims for post-conviction relief. And even if you come up with new evidence later that really undercuts your conviction, you can't come into court with that new evidence unless it clearly and convincingly establishes you're innocent. Extremely difficult standard to meet. We have what's called the NAFLA bar, which is the rule that says that if something has already been litigated, you can't litigate it again, even if it wasn't litigated, but it could have been earlier litigated by your appellate counsel or in a previous application for post-conviction relief. You are forever barred from bringing that again. Another difficult thing about post-conviction litigation is that you're always trying to find some kind of deprivation of procedural rights, whether it's a due process violation, a Sixth Amendment violation of your right to counsel. It's not enough in most jurisdictions to come in and say, I'm innocent. You've got to find something to hang your hat on that shows that some of the procedures that led to your convictions were faulty. And as we get into federal court, it gets even more difficult. Many of you are probably aware of the Anti-Terrorism and Effective Death Penalty Act, otherwise known as AEDPA, signed into law in 1996 by Bill Clinton, which creates an extremely high barrier to relief on federal habeas review. It's not enough to say that the state court got the constitutional issue wrong. They have to have unreasonably applied it in light of directly controlling Supreme Court law. So very, very difficult standard to meet to get relief in federal court. One of the ways potentially around those problems is through conviction review units. That's becoming more and more common in jurisdictions around the country, where the prosecutor's office will have their own unit that they will establish to review their own convictions, which is really in keeping with the duty of the prosecutor to be not just someone who accumulates convictions, but who is a minister of justice. So sometimes prosecutors' offices will establish their own unit to review their own convictions. And regardless of what procedural objections they may have to post-conviction relief, regardless of what the statute of limitations issues may be, if the prosecutor's office believes that they've got a conviction that lacks integrity, they will take steps to remedy that. Here in Minnesota, as you see in this picture, we have a statewide conviction review unit that's housed at the Minnesota Attorney General's office. That was commenced through a partnership between our organization and the Office of the Attorney General. And they are reviewing cases, and we're going to talk about one of those cases that they've reviewed today. Benefit of that conviction review unit mechanism is that it's a way around the statute of limitations and abusive process and procedural rights requirements. And it's a way around the high burden of federal habeas review, a way just to get to the heart of the matter and look at the key question, which is, does this conviction have integrity? Thomas Rhodes' case is a case that was reviewed by the Minnesota Conviction Review Unit. That's a case that involved a lot of the things that I've talked about, including bad forensic evidence, some prosecutorial misconduct, and some other issues. This is Thomas Rhodes, along with his wife Jane and his sons Jason and Eric. This picture was taken in 1995. In 1996, the family went on vacation at Green Lake in Candy, Ohio County. That's the kids on this vacation out on the floaty in Green Lake in 1996 with their dog. The boat they were using at the time was this Baja Blast, which is a jet-propelled boat. One thing that's important to know about that boat is that it's got low gunnels, as you can see. It's not, necessarily the easiest boat to stay inside when you're driving around quickly. And that becomes important in this particular case. So Tom Rhodes and his wife Jane and the kids were on vacation at Green Lake. One night after the kids were in bed, Tom and Jane go out on a night boat cruise. It's midnight or after midnight. Green Lake's a fairly large lake. It's dark. Lake's over 5,000 acres. They're going around on this Baja Blast boat. Jane is not a confident or a strong swimmer. So she and Tom are riding around. As Tom explains it, at some point they're going to move to a different area of the lake. He was driving the boat. Around that time, Jane had lost an earring. And so she's kind of looking around for the earring. And at some point, just as he is turning on the boat to steer, these jet-powered boats, you can't really steer them unless you accelerate and the boat is moving. Just as he accelerates, she stands up to look around for the earring and she falls out of the boat. And in fact, later on, when law enforcement did a search of the boat, they did find an earring on the floor of the boat. In any event, Jane goes overboard. Tom turns around to look for her. He drives around the boat trying to find her. And after a while, he can't find her. And so he takes the boat back to shore, runs into one of the establishments on the shore, and has someone call 911. Search is conducted. They're unable to find Jane on the lake that night. The search continues. And, more than a day later, some fishermen find her body at a different part of the lake. Tom is ultimately prosecuted, and the state's theory is that he murdered her. The state presented testimony from the medical examiner, Michael McGee. This image you see on this slide is not the actual body. This is a reconstruction. This is a clay model that was used at trial. It was used by the prosecution to demonstrate what they said were the injuries Jane had suffered that were pre-mortem injuries. In other words, the state's theory was that Tom had administered a severe beating to Jane on the boat before pushing her overboard. And the evidence of that, they said, was these pre-mortem injuries on her head and face. So Dr. Michael McGee was a medical examiner. The autopsy he didn't perform until 70 hours after her body was pulled from the water. You can imagine how that would complicate the autopsy and make it more difficult to sort out what were pre-mortem and what were post-mortem injuries. But Dr. McGee said he observed marks covering her upper facial area, which he said were bruises that could not be caused by a single blow, but that there must have been multiple strikes to Jane Rhodes before she died. Also important was the fact that Jane Rhodes's neck did not have any external signs of injury, but he did observe soft tissue hemorrhages on the inside of the neck. And so Dr. McGee testified to the jury at Tom Rhodes's trial that those were caused by external pressure, such as a hand in the V formation. The prosecutor would then say in closing argument that Thomas had knocked her out of the boat, perhaps with a blow to her neck. Dr. McGee also testified that some bruising on Jane's forearms were defensive wounds that again showed that there was a struggle on the boat. She was trying to defend herself against an attack by her husband. And Dr. McGee testified that Mrs. Rhodes could have died from these injuries to her head and neck, even if she hadn't drowned in Green Lake. Very powerful testimony from the medical examiner that led to Tom Rhodes being convicted of first and second degree murder and sentenced to life in prison. He did have the possibility of parole after 30 years, but the issue for Tom was that he would never be released on parole because he wouldn't admit guilt and he couldn't show remorse. He couldn't accept responsibility. Which generally speaking, you're not going to get parole if you don't do that. That's a big problem for people who are the victims of false convictions, this horrible choice between admitting to something you didn't do or remaining in prison. There were a number of post-conviction proceedings. I think it wasn't until the fourth of them that the Innocence Project got involved in his case. By this time, we had 7 experts, but 2 had already looked at it. So in post-conviction, a total of 9 new experts reviewed this case. Each and every one of those 9 experts, after looking at all the evidence, disagreed with Dr. McGee's conclusions. None of the 9 experts who reviewed the case in post-conviction would have called this case a homicide. All of the 9 experts who reviewed the case in post-conviction said there were, in fact, no signs of a struggle, that the abrasions on Jane's face, arms, and hands were from post-mortem dragging along the bottom of the lake in a face-down position. There was a mouth laceration that Dr. McGee said was a stretch injury. Again, must have been a physical struggle pre-mortem. The other experts all said that no, that was the product of predation by aquatic animals, not uncommon in drowning victims. And the hemorrhages in the neck that Dr. McGee said showed a blow to the neck by Tom Rhodes's hand. That was actually the leakage of blood vessels. It's a common injury in drowning victims. And in fact, there was new scientific literature studies performed on drowning victims that showed that this was a very common occurrence in the cases of drowning. It wasn't evidence of some pre-mortem blow to the neck. In post-conviction, the state does not present a single expert who could take Dr. McGee's side of this dispute. Over time, there was increasing skepticism about this particular medical examiner. In fact, in 2021, a federal judge in North Dakota examined Dr. McGee's testimony in a death penalty case and made some pretty stark critical findings about McGee. This is quoting from that opinion in U.S. versus Rodriguez. The court begins its analysis with the public and troubling fact that longtime Ramsey County medical examiner Michael McGee has a well-documented history of providing false or inaccurate testimony in court. He goes on to say that the common thread in cases involving McGee is that he would interpret the evidence from his autopsy examination in a manner that was subsequently determined by other physicians, other pathologists to be unsupportable. McGee's testimony was so critical in 2 of the cases that after his opinions were cast into doubt, a new trial was ordered and ultimately charges were dropped. So a real problem coming to the surface about Dr. McGee's testimony in a number of cases. I mentioned the case of Michael Hansen before, the medical examiner who made the conclusion that Michael Hansen had murdered his baby, also Dr. Michael McGee in that case. Nevertheless, Tom Rhodes got nowhere in his 4 post-conviction proceedings. He was denied over and over again. In fact, in the most recent post-conviction hearing, the district court judge denied a hearing. They said the petition is time barred, it's procedurally barred, it's cumulative. As I mentioned before, he was trying to come in with new evidence because it was more than 2 years after his conviction. He had to establish innocence by clear and convincing evidence. This is a circumstantial evidence case. How is he going to prove by clear and convincing evidence that he didn't kill his wife? It's not like he's going to be able to find an alternative perpetrator through DNA evidence. It's a very, very difficult standard to meet in a case like this. And the court said that he can't meet that standard because this is merely contradictory testimony by equally qualified forensic pathologists. Essentially, the court said, we've just got a battle of the experts on this case, threw up its hands and said, we can't grant post-conviction relief in that situation. It provided a perfect opportunity for the conviction review unit to do an investigation, and that's what they did. They did an extensive investigation, and this is all quotes from the report issued by the Minnesota Conviction Review Unit. They uncovered evidence that cast substantial doubt upon the expert medical testimony presented at trial. The CRU could find no evidence to support Dr. McGee's opinions. And in addition to the 9 experts that we had review the case, the Conviction Review Unit found its own independent medical examiner to thoroughly review all of the medical evidence. This 10th expert also found Dr. McGee's opinions unsupported and noted that this case was very similar to other cases where McGee's evidence led to wrongful convictions. In addition, the CRU was able to do something that none of the lawyers representing Mr. Rhodes were able to do in the 3 previous decades of post-conviction litigation. they were able to get access to the files of the Candy, Ohio district attorney. And in those files, they uncovered a memo of a meeting with Dr. McGee, at which Dr. McGee said that he could not determine whether the injuries to Jane Rhodes were the result of one blow or multiple blows. This is completely contradictory to his trial testimony, which was that absolutely there were multiple blows that showed that there was a pre-mortem struggle on the boat. Completely covered by the Brady rule, was never turned over before the trial, and was never turned over in 4 rounds of post-conviction litigation after that. But for the involvement of the conviction review unit, this memo would probably never have seen the light of day. But as a result of the conviction review unit's investigation, their report and recommendation, and some cooperation from the Candy, Ohio District Attorney's Office, Tom Rhodes actually was freed in January 2023. That's the image of him leaving the prison with his 2 sons, January of this year. So what are the takeaways from the Tom Rhodes case? It's a great illustration of the problems of all of the procedural barriers we have to post-conviction relief. It also shows, as we've seen, the potential value of having a conviction review unit, even though the outcome in this case was unsatisfying. I say that because in this case, the result was essentially a plea deal where the district attorney agreed to vacate the murder conviction in exchange to an Alford plea for involuntary manslaughter. Essentially, they said he was operating the boat in an unsafe manner. An Alford plea means a plea where you admit that the state has enough evidence to convict you, even though you don't admit to being guilty of the crime. Tom Rhodes was faced with a very difficult decision. He could face potential life in prison, or he could take this deal and go home immediately and be reunited with his family. He took the deal, but as a result, he still got a felony conviction on his record and all the problems that come with that. It means he's ineligible for compensation under Minnesota's wrongful conviction compensation statute too. So there's some definite trade-offs there. What else have we learned from this case? We've learned that it needs to be vigilant when it comes to bad forensic witnesses. And as a result of this case, the Minnesota Attorney General's office is conducting an audit of convictions obtained through the testimony of Dr. Michael McGee, where the Attorney General's office was the prosecuting authority. Ramsey County is doing a similar audit of McGee cases. And that's important. And it shows that prosecutors need to scrupulously adhere to Brady obligations, because when they don't, we get cases like this one. This is a more recent case. This one is near and dear to my heart because it's a very recent case and it's still ongoing. This is the case of Cassandra Black Elk. This is Cassandra here. She's holding her newborn baby, whose name was Starlight Black Elk, who was born in 2019. I'm sorry, in 2022, excuse me. This case starts in this house where Cassandra lived in Bismarck, North Dakota, where she lived with her 3 children, Starlight, the baby, and then she had 2 slightly older daughters. They were in this house one night, and the kids went to bed at around 9-10 o'clock. Cassandra and her boyfriend were in the house. They'd gotten into a fight at some point that night, and her boyfriend left around midnight or so. At 1 o'clock, Cassandra got Starlight up, the infant, gave her a bottle, swaddled her, put her back down to bed, and went to sleep. At 6 a.m., Cassandra woke up, and every parent's nightmare scenario, Starlight was totally unresponsive. She couldn't wake her up. She called 911 immediately. First responders came, and Starlight was pronounced dead when they arrived. Terrible, terrible situation. And to make it worse, Cassandra Black Elk was taken straight from this house, the scene of her child's death, to the Bismarck Police Department and put in an interrogation room and questioned for 3 hours. You can see, I think from the body language here, the aggressiveness of the interrogation. Police had become convinced that either Cassandra or her boyfriend had caused the baby's death. They either believed or they suspected that there was some kind of bruising or injury on the baby. In any event, they were convinced that Cassandra was responsible. One of the things they observed was there was some open beer bottles in the kitchen, and they got Cassandra to admit that she and her boyfriend had been drinking that night when they got into the fight. When they pressed her about the details of the fight with her boyfriend, she referenced the fact that she'd been drinking and that it made it more difficult for her to remember. So during this 3-hour interrogation, which commenced, within an hour or two of the death of her baby, the police told Cassandra that there was bruising on the baby's head and back. That wasn't true. There was no bruising on the baby. They told her they believed that she had shaken the baby. They explained to her all about shaken baby syndrome and how that must be what happened here. Also not true. She had not shaken the baby. They even told her that based on the progression of rigor mortis, that they knew she was lying, that the baby had died the previous evening before Cassandra had given her the bottle, claimed to have given her the bottle at 1 a.m. and gone to bed. So throughout this, Cassandra maintains that this wasn't true, but the argument continued and the police ratcheted up the pressure after that. They said she had two choices. We know, Cassandra, either you're a bad person or you're just a person who needs help. This is a classic interrogation technique of minimizing the conduct to try to get an admission. We know you did this. The physical evidence shows it. Just tell us which one it was. They told her that the autopsy would show that she was responsible for the death, so it would be better for her if she would just admit her responsibility. And they told her, most troubling, that her two other daughters had been taken away and placed with Child Protective Services, and that she, Cassandra, was unlikely to get those children back unless she confessed to what she had done to Starlight. You can imagine the kind of pressure that involves on a young mother who's just gone through what she's been through. But she resisted. As I said, her story didn't change. She said Starlight was fine when she gave her a bottle at 1 a.m. before swaddling her and putting her to bed. She insisted Starlight had no bruises. Police kept asking her, well, what do you think happened? And each time she would say she thought it was SIDS. And each time she said that, the police would say, SIDS is not real. That's not a thing. It doesn't happen anymore. We know that. We know you're lying. So at the end of this interrogation, Cassandra is immediately arrested. She's taken to jail. She's charged with felony child neglect. And this is from the affidavit of probable cause that was filed. Basically, they're saying, while at this time, the exact mechanism of death is unknown, all we're waiting for is the autopsy. What we do know is that her intoxication level impaired her ability to care for Starlight to a point where Starlight died. So they're saying she caused the death. We don't know exactly how she did it, waiting for the autopsy for that. Around the same time, here the formal charging documents, again, saying Cassandra consumed alcohol to a level that impaired her ability to care for Starlight, and Starlight died due to a lack of appropriate care. Again, Cassandra is responsible for this death. We may not know exactly how, but we know that the baby died due to her conduct. This was just brutal coverage in the press of this case. So as she's sitting in jail, being repeatedly denied bond, separated from her other two children, her case is lumped in with another horrific case of child abuse, where a child is beaten to death, and her mugshot, which is the one in the bottom right, is placed right there next to these other mugshots of people involved in this other case of beating a 5-year-old to death. This is just one example. All of the Bismarck papers had this mugshot of Cassandra, along with some kind of allegation about how she caused her baby's death. The autopsy does occur. It occurs on February 2nd, which is the same day that Cassandra Black Elk was charged. The Burleigh County State's Attorney, several law enforcement personnel attend that autopsy. And at that autopsy, the medical examiner told those people present, I don't see any evidence of any recent significant injury to this child. There's no bruising. There's no sign of trauma at all. There's no sign of foul play. Over the next few months, Cassandra is asking her defense lawyer, when are we going to get the autopsy report? I really want to see it. They're saying I killed my baby, and I'm telling you I didn't. We need to get it. But she's not getting it. By May, she still doesn't have it. Now she's already been in custody, separated from her other daughters for a few months because she couldn't make bail. At that point, her lawyer encourages her to take a plea deal. The prosecutor offers a deal where she pleads guilty to the charge of offense, felony child neglect, which carries a 5-year sentence. Some of that would be suspended. Her lawyer tells her, don't worry about it. You'll be out of prison before you know it. She said, she's never been to prison before, by the way. And when she keeps asking about the autopsy report, he tells her, we'll just deal with that later. Take the plea deal now. If the autopsy report comes in, we'll deal with it later. I'm not sure what he meant by that, but it's not great legal advice. But she does it. In the state that she's in, she pleads guilty and she goes to prison. By the time of this plea deal, which is now months after the autopsy, the state still had not disclosed the fact that the autopsy showed no signs of injury on the baby. Finally, when she's in prison, Cassandra doesn't give up. She keeps trying to get the autopsy report on her own, not even with the help of counsel. She's calling, she's writing to the medical examiner, and finally she gets a copy of it. And it says exactly what she thought it would say. It observes that the body of this child is normally developed. It's a well-nourished, well-hydrated female infant. The review of the scene photos show that it's a well-kept home, ample age-appropriate toys and supplies, no evidence of foul play, no evidence of recent significant trauma. This is a sudden, unexplained infant death. There's nothing to suggest that anything Cassandra Black Elk did or didn't do caused the death of the baby. So we go into post-conviction. We have a hearing. Cassandra Black Elk testifies about everything that happened, about the advice she got from her lawyer. And ultimately, the district court concluded that in advising Cassandra Black Elk that they could just deal with the autopsy report later after the guilty plea, that fell below the standard required of a defense attorney. Court didn't rule on the Brady issue, but it also noted its concerns of the allegation that the state knew of the likely results of the autopsy report prior to the plea agreement, but did not relay that information to defense counsel so that Cassandra could have been appropriately informed before making her decision whether or not to plead guilty. So suggestion that if it were to rule on the Brady issue, that it would rule, against the state. So Cassandra was released the same day, or at least a few days after that decision came out. You can see the transformation here. There she is reunited with her other 2 kids, which is wonderful. But the sad thing about this story is that it's not over yet. The state appealed that decision, even though Cassandra had already served over a year in prison on this bad conviction. The state decided to appeal the decision up to the North Dakota Supreme Court, apparently in an effort to strip her away from her babies again and put her back in prison. So we had the hearing in front of the North Dakota Supreme Court on the 26th of June, and we're waiting for a decision on that. Even if we win in front of the North Dakota Supreme Court, the state will have the option to try to retry or at least go to trial against Cassandra Black Elk under the theory that somehow she committed felony child neglect by, I guess, drinking. And one of the things that comes up in this case, in terms of what went wrong and what we learned from it, I guess I would go with the 4th bullet point first. And I can't prove this, but I wonder about the role of implicit bias based on her ethnicity. I wonder about how many times, the state is now taking the position that a mother who consumes alcohol to the point of intoxication, who has young children at home, commits felony child neglect, that alone is enough, even if no one is put at direct risk or harm from the drinking. I wonder whether that case would be charged out where a white woman, relieves the nanny after having a few too many martinis after the kids are already asleep. I also wonder about whether a defense lawyer would think that serving 18 months or more in prison would not be that big of a deal for a white woman who's never been to prison before. The other things this case involved, though, a rush to judgment, clearly by the police and by the prosecutors, and then a refusal or failure to revisit their bad conclusions when the evidence didn't support them. I think we get this tunnel vision phenomenon a lot of times in law enforcement and in prosecutors that can be very pernicious and lead to false convictions and lead them to defend a conviction that they should know better than to defend. The other thing this involved was a lawyer simply not listening to his client. She's proclaiming her innocence. She's insisting that the autopsy will show she didn't do anything. She was a good mom who took good care of this baby, but her lawyer didn't listen to her and maybe didn't even believe her. and maybe told her to take the deal because he thought the autopsy would show otherwise. I don't know, but a lot of problems with this case, and the fight is continuing. We do have a GoFundMe for Cassandra. I'm not going to show it to you at this presentation, but if you're interested in contributing as she tries to put her life back together, send me an email and reach out, and I can send you the link to that GoFundMe. That's what I've got for you. I've got a few minutes for questions. If anyone's got them, let me check the chat now. Did she file? I'm sorry, go ahead.
Yeah, if you want to address the ethics complaint question, there's also another one that I received directly asking about the impact of the Shin v. Ramirez decision on the Innocence Project's work.
Yeah. Well, let me start with the last about the ethics complaint. She didn't file an ethics complaint against her lawyer yet, and that's always the difficult thing in these cases of, does it rise to the level of being a violation of the rules of professional conduct every time a lawyer's representation falls below the minimum standard under the Sixth Amendment? She didn't do it. I would say that the case is ongoing. It's working its way through the appeals process, and I don't know where it's going to end up. The scary thing for us is that I think it's important for there to be consequences for lawyers who violate their professional responsibilities. At the same time, it's important for us to have cooperation from lawyers who violate the Sixth Amendment, who don't live up to it. And so it puts us in a difficult position where the worse the consequences are for the lawyer, the less likely it becomes for them to cooperate with us in later cases, and the more likely they'll simply try to cover themselves by coming up with strategies or saying things to suggest that their representation was in fact just fine. So it's always a tricky thing for us to navigate. Shin versus Ramirez, I haven't directly run into the problem yet, but that's obviously a case that we looked at with great concern. For those who aren't familiar with it, it was a case that further undercut the ability to get federal habeas help for a wrongfully convicted person by suggesting that the defendant was basically stuck with the factual record that they developed in state post-conviction. They couldn't develop the record factually further in federal court, even if they could show that their state court representation was ineffective by failing to develop that record. So it kind of created this catch-22 where there's no way to create an adequate record to show that your state court lawyer was ineffective. So we haven't in our organization dealt with it directly yet, but we're certainly concerned and worried about it. Is this full-time work, or is it something that other lawyers could help with pro bono? We do have a pro bono program that we're currently building up on a lot of these cases, especially the bigger cases. We will partner with law firms or lawyers to help us do the work. So we've got, 3 full-time legal staff at the moment, but we do rely on some partnerships with pro bono lawyers as well. And if you're interested in volunteering, I suggest that you check our website, and I think we've got something you can click on in order to express your interest in
Jim,
volunteering.
This is Haley. I just dropped that link in the chat for everyone.
Oh, thanks, Haley. And Haley just dropped that link in the chat. Excellent. Yeah, ethics complaint against the prosecutor. I'm assuming you're talking about the Black Elk case. I mean, we're still fighting it. So no, nothing's been filed yet. There's been no finding in court yet as to whether there was a Brady violation there. Of course, the prosecutor still insists that everything they did was fine. They're claiming that because this was felony child neglect and causing a death or even causing harm is not an essential element of the crime, that they weren't required to turn over the information they learned at the autopsy. And also the autopsy report, by kind of just a quirky fact pattern, the final autopsy report wasn't available until after the plea was entered. And so there was no written report to turn over at that point. But again, that's a sticky situation about when a prosecutor should be reported for unethical conduct for a Brady violation. I think I'm out of time, but I just want to thank everybody for listening and for being interested and for your time. I hope you found it interesting and informative. And thank you, Sarah, for helping me connect with everyone.
Thank you so much for the presentation. We're going to go ahead and stop recording.